The question is that the bill be now read a second time. Mr. Christopher de Souza.
Sir, two of the three stated objectives in the long title of the Legal Profession Act are to constitute the law society and to amend and consolidate the law relating to the legal profession. The legal profession plays an important role, an integral role, in the administration of justice in our rule of law society, through ways such as providing legal advice, representation, and promoting legal literacy through education. Lawyers play an important role in access to justice. This bill furthers their efforts and the legal profession's contribution to society. Firstly, this bill facilitates the law society to perform functions and activities better. It provides for wholly owned subsidiaries which would allow the law society to make use of separate legal entities to perform functions and activities. One of these functions could be pro bono services, as Clause 4 also allows solicitors employed under the wholly owned subsidiary to apply for a practicing certificate. This is also supplemented through Clause 19 that allows the wholly owned subsidiary to use accretions to capital from the compensation fund. Through the new 70J3 subsection B, the new unclaimed money fund would also complement that financial support for the law society's pro bono services and the activities of a wholly owned subsidiary. These amendments would support the ongoing pro bono efforts by the society. At this point in time, I should declare that I am a legal practitioner at the Singapore Bar. One of the stated missions of the Law Society is to ensure access to justice for all. And one way this has been done is through pro bono services. Some of the excellent work is reflected in the Community Legal Clinic Scheme, the Criminal Legal Aid Scheme, and the Ad Hoc Pro Bono Referral. Not restricted to individuals, the Law Society also works with VWOs and charities who are unable to afford legal consultation and representation due to limited resources. Law awareness seeks to break legal jargon into accessible, easy-to-understand elements for the public through talks, exhibits, resource materials. Therefore, these welcome amendments enhance the Law Society's contributions to our community. Secondly, sir, the bill furthers the drive to make Singapore a robust, regional, and global legal hub. Clause 30 introduces a new Division 5 that would regulate group practices in Singapore by Singapore and foreign law practices. This provides for another option that law practices may choose to organize themselves within, allowing for more flexibility in how practices may choose to position themselves in the legal industry. This bill also provides for law experts to appear before the Singapore International Commercial Court and relevant appeals in the Court of Appeal. The expertise from which the SICC can draw on in a proceeding is no longer limited to practicing solicitors, persons admitted under Section 15 ad hoc admissions, or foreign lawyers registered under Section 36P. But these legal experts serve a separate function. They come into the picture when the SICC orders that a question of foreign law be determined on the basis of submissions instead of proof. Thirdly, this bill seeks to further regulate the bar. On this theme, I have two clarifications for the Minister. Firstly, I would like to ask for an elaboration on Clause 20, new Section 75E, which provides for declaration of practice areas on practicing certificates unless exempted. May I ask the Minister, what is the thought behind this and how would it work? My second clarification for the Minister is on the introduction and expansion of remedial measures. While it may provide for an intermediate option in addressing situations, the bill sets few parameters on what kind of remedial measures Council can make under the new Section 97A. While ministerial approval is necessary, it seems as though the power is constrained only by the purpose of the rule, that is, new Section 97A, paragraph A, which says to address any issue concerning the professional practice, etiquette, conduct of discipline of a regulated legal practitioner, unquote, and paragraph B, I quote, any requirements that Council may specify for compliance with an order of the Council under sections 88(1)A or 94(3)A, unquote. The latter seems to include warning, reprimand, and financial penalty as remedial orders. My clarification for the good minister is this. Why are the safeguards in sections 88 subsection 2 and section 88 subsection 3 not extended to the new subsections 1A and 1B, even though they may carry similar consequences? In short, my position in short is that any remedial actions must also be fair to the practitioners, and the process in deciding whether a remedial action should be and let me say that again. In short, my position is that any remedial actions must also be fair to the practitioners, and the process in deciding whether a remedial action should be administered should also be fair to the practitioner. Fourthly, sir, through the setting up of the unpaid money fund, clients' interests continue to be safeguarded while providing a practical solution for some solicitors' conundrums. These changes would allow lawyers who wish to retire to do so by relieving lawyers of the burden and expense of maintaining a client account. This is especially pertinent as the solution mechanism of intervention money being paid into the compensation fund does not reflect our current legal industry landscape, where law firms may not always continue across generations. Hence, the unpaid money fund would allow solicitors to avoid this conundrum in the future. Furthermore, these unclaimed monies can be used for a public good. The new section 70J, subsection 3B, in clause 18, provides that it can be used for pro bono services provided by the Law Society or by any wholly owned subsidiary of the Society, unquote. Sir, even as this solution provides a win-win situation for the community and the relevant solicitor, it will also provide sufficient safeguards to ensure clients' interests are not compromised. The purpose under which a solicitor may apply to transfer money into the unclaimed money fund will be restricted under section 70J 2 and 3. Claims against the fund are also allowed up to 6 years after the transfer, after which the Society still retains the discretion to pay part or whole of the amount being claimed. In this manner, the unclaimed money fund provides a practical win-win solution for all. Sir, the legal profession has an important role in ensuring that Singapore remains a country run on the rule of law. This bill augments that aim, and therefore I support it.